Welcome to our tutorial lessons on the law of tort, episode 7. You may recall that during our 6th episode, we treated the rule in Wilkinson and Downton, where we identified 3 elements to prove in order to be successful. That episode saw the end of the lesson on trespass to person. In this episode, we are moving to another branch of trespass in tort, and we are looking at the tort of trespass to land as the area of law under tort. We need to first and foremost state that we have jumped the defenses to trespass to person because we intend to treat all defenses under tort in our last batch of episodes on tort before our last session on tort. Today, we are going to identify the elements in the tort of trespass to land and highlight the major principles you will need to explain these elements to help you appreciate how to apply them. First and foremost, what is trespass to land? Trespass to land is also called trespass quae clausum fregit, which means direct interference with land in possession of another. This tort, in simple terms, deals with impermissible or unlawful entry into someone else's land space by another or an object of another person without any lawful excuse. Trespass to land is actionable per se, thus a person whose land is entered upon may sue even if no harm is done. Thus, what must a person prove to be successful in an action of trespass to land against another? The 6 elements are direct acts by the trespasser, positive act, physical interference, lack of consent, voluntariness, and state of mind of the trespasser. Let's now look at these elements with their principles. Direct act. In Pickering and Rad, the house of Rad adjoined the garden of Pickering. A Virginian creeper which grew in the garden of Pickering spread itself over the side of Rad's house. Rad, a barber, decided to hang a signboard on that side of the house covered by the Virginian creeper. He managed by means of ropes and a scaffolding suspended over the garden without touching the surface of Pickering's premises to cut away such a portion of the seasonic 3 to 4 inches from the surface wall. Pickering sued Rad for trespass, alleging both the cutting of the creeper and the projection of the board into his airspace. Rad justified the cutting by the fact of its projection into his premises. Pickering argued that more harm had been done by Rad than was necessary. Lord Ellenborough held that it is a trespass to fire a gun into someone's land. Lord Ellenborough also said it would not be a trespass to pass over a man's land in a balloon, that trespass requires a direct act. This case also signifies the situation where it would be trespass to land if a person causes an object such as anything that has size and mass to come into contact with the land of another. In Gregory and Piper, Littledale J and Park J therefore reaffirmed the principle under directness by stating that a person is liable for the natural and probable consequences of his act. The next element is positive act. For this element, you may recall what we did under battery on the same element, where in summary we established that one must be held to have committed trespass if he actively does something and not omits to do something. The next element is physical interference. In Lavender and Beds, where the landlord removed the windows and doors to make staying considerably uncomfortable for the tenant, the principle was laid by Lord Atkinson that the physical interference with the possession of someone else's land would be sufficient to amount to trespass to land. Contrast this case with the case of Pereira and Vandia, where the landlord cut off the supply of gas and electricity from his end of the premises without physically coming into contact with the tenant's premises, of which it forced the tenant to leave. Roma L.J. in distinguishing Lavender and Beds from this case stated that as the landlord's action did not constitute an interference with any part of the tenant's premises, it could not be regarded as a trespass. A lesson from the case on this third element is that although the action of the landlord in cutting off the gas and electricity was a deliberate and malicious tort, but that it did not amount to a tort of trespass since it did not constitute a physical interference with any part of the demised premises. Another principle to note under this element is that trespass deals with interference with the possessory rights of a person and not ownership rights, as established by Justice Singh in Isaacs and Rodney. The fourth element is lack of consent. The principle is that a person commits trespass to land if that person does not have the consent of the one in possession of the land or where the consent is revoked. Also, where a person enters someone's land with the leave and license of the landlord, then the licensee becomes a trespasser if he refuses to leave after the license has been revoked. That is, if he overstays, provided he has been given reasonable time to leave the premises. What is reasonable time will depend on the situation. For this principle, let's see how it's demonstrated in 3 cases. First, in Hearst and Picture Theatres Limited, Barclay LJ held that a person does not become a trespasser where the occupier consents to his being on the premises and the payments made to be on the premise constitute such consent. So from the case, it was established that the purchaser of a ticket for a seat at a theatre or other similar entertainment event has the right to stay and witness the whole performance, provided he behaves properly and complied with the rules of management. The license granted him by the sale of a ticket includes a contract not to revoke the license arbitrarily during the performance. Second, in Cowell and Rosehill Racecourse Company Limited, the principle established was that consent to enter upon land can be revoked, and when a person remains on the land following the revocation of the license, he becomes a trespasser. In this case, what happened was that the plaintiff had paid 4 shillings to watch a race meeting being held by the defendants. In the course of the meeting, the defendants asked the plaintiff to leave, and upon his refusal, forcibly removed him from the course. The plaintiff, being inspired by the decision in Hearst Picture Theatres Limited, alleged further that he had acquired a right to be there which could not be prematurely revoked and that the purported revocation was ineffectual. The court, in following the decision in Hearst, held that no action for assault would lie, reasonable force having been used for the removal. This is because the plaintiff merely had a contractual right which was revocable and not a proprietary interest in the land. If the right was unjustifiably interfered with, his proper course would be an action for breach of contract. Thus, the court declined to follow the decision of Hearst. Since then, the conclusion in Cowell has been preferred to that of Hearst. So note once again, if you're on somebody's land with his permission, then you commit no trespass. You become a trespasser only if he revokes your license and you still remain thereafter. Third, in Robson and Hallett, the court established that after revoking the permission, the person must be given reasonable time to leave. Once a person enters the place, it is required that the person is given reasonable time to leave. So after revocation of the license, and after, then reasonable force could be used to get that person out. However, a person's right to consent has a limit, and let's see the principle on that limitation as established in the third case. In Robson and Hallett, Lord Parker CJ made it known that the occupier of a dwelling house gives an implied license to a member of the public who comes to his premises for a lawful business. So if a police officer comes to your land to make an inquiry, particularly under a warrant, you will be deemed to have given consent to the police and there will be no trespass to land. The fifth element is voluntariness. The principle as per Rose CJ in Smith and Stones is that the acts complained of must be a voluntary act, and for this purpose it is immaterial if one knew he or she was trespassing or not. However, if the trespass is caused by others, causing one to be in contact with the land, then one is not liable, but the trespass will be against those who brought him onto the land. However, in Gilbert and Stone, Rose CJ stated that Where the act of the defendant is voluntary, it is not a defense in trespass to say that one enters the land of another for fear for his life or under some compulsion, since the trespasser had a choice to make. In Basley and Clarkson, it was reaffirmed that the intention and knowledge of a trespasser is irrelevant to his liability, provided the act was voluntary and the mistaken belief of the defendant is not a defense. Take note that voluntariness deals with one having control of himself or the act. On the last element, which is the state of mind of a trespasser, we invite you to read on that and write the principle you find on this element in the comment section of this video, and we will acknowledge the person with the right principles during our next session. Before we go, let's take a look at who may sue and trespass the land. In Butalfe and Dankwa, Lord Guest held that a person in possession of land can sue for trespass even if he has no title to the land. In order to maintain an action for trespass, the respondent must have been in possession at the date of the appellant's entry on the land, and the presence of pillars exhibited that possession. This was affirmed in Nunepeku and Amitipe. So proof of ownership is prima facie proof of possession. So is occupation. However, the rule as applied in Mensa and Peniana is melior est conditio possidentis ubi neuter his habit, which means where both plaintiff and defendant are trespassers, then the defendant will prevail. Also, in Uedu and Mem Timber Company Limited, Olenu J observed that it was settled law that a person in possession of land, though himself a trespasser, is entitled to maintain an action for trespass against any person who deserves his said possession, except the person in whom title to the land is vested, or anyone claiming in the rights of the true owner, that is, an agent or representative. Take note that Lord Brown Wilkinson in Power and McFarlane indicated that possession of the land requires two important elements, namely factual possession and the intention to possess the land. Please find the Latin terms for these two elements required for possession and let us know in the comment section. Concluding, we will treat subject matter of trespass under our next series on immovable property, what is land. But for now, you may also let us know what you think constitutes the subject matter of trespass and the scope of same in the comments below. This is the end of our 7th episode. We hope you learned and you will join us for our next episode, which will be on trespass to chattel. Please help us share this channel to everyone. Like our videos, comment and subscribe. Thank you.